Welcome to Standard Deviant School, American Government. I'm Christiana Knight. Our program today is the judicial system. We've all heard about the Supreme Court, right? But do you really know what goes on in those hallowed halls? How do the justices decide their cases? How do they get on the bench?
Hey guys, here's what we're going to cover today. First, a little history. Then we'll introduce you to each level of the judicial branch, the federal district courts, the circuit courts, and the Supreme Court. And we'll describe the roles of each. Then we'll find out how justices are selected, how cases make their way through the courts, and give you some insight on how the justices decide their cases. Let's get started.
Woodrow Wilson said some 100 years ago that the Supreme Court is the balance beam of the whole constitutional system. Yet, some 100 years before that, in 1787, Alexander Hamilton called the judicial branch the least dangerous branch of the United States government.
Well, how can this branch go from being virtually powerless to being one of the most influential within the constitutional system? Taking a look at the creation of this branch might help us understand why.
Article 3 of the Constitution gave America its judicial branch when it said,
"The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish." Which means, hey everybody, how's about a government branch that interprets our laws?
When this part of the Constitution was first written, not all citizens agreed to this court system. There were two main schools of thought, the Federalists and the Anti-Federalists. Alexander Hamilton was a Federalist. He and all his Federalist buddies saw the new Supreme Court as the least harmful branch in the government. But the Anti-Federalists weren't so blasé about the whole thing. The Anti-Federalists felt that a branch of government made up of people with a lifelong tenure was dangerous, especially since they had the power to interpret the meaning and importance of the supreme law of the land. Supreme Court justices would be justices until they died or stepped down from office according to the Constitution.
Well, the Anti-Federalists did have a point. Article 3 was a bit vague when it came to the structure of the Supreme Court. That's why, in 1789, the Judiciary Act of 1789 was passed.
The Judiciary Act of 1789 established the three-tier structure of the federal court system. Those three tiers include the federal district courts, the circuit courts, and the Supreme Court.
Before we get any deeper into the world of the judicial system, you should know a quirk of the American legal system.
Specifically, the American legal system has made several names for itself. The first name is the dual system. You see, while there are all those federal courts and the courts of appeal and the Supreme Court, there's also another arena for law in this country, and this is thanks to the dual system.
The dual system consists of the federal court system we just outlined and the individual judicial systems at the state level.
Secondly, known as the three-tiered system, the American judicial system contains three different levels of courts within both the federal and state levels. Each tier has a different jurisdiction.
They are the trial courts, the appeals courts, and the Supreme Court.
Let's see how each of these courts fit together to form the big judicial system.